Thank you, Chair Irwin and members of the committee for taking up these important bills, Senate Bills 372 to 375. Collectively, these four bills provide some protection for renters around application fees, transparency in fees, provision of a fee-free method for paying rent, and sealing and expungement of eviction records under certain circumstances. I'll start off briefly with my bill, and then we'll turn it over to Grace here to talk about Senator Cavanagh's bill. Then we'll speak to your bill, Mr. Chair, and then I'll finish it up with the last one. So I think we're good to go. Senate Bill 372 is the first bill in the package. It puts a cap on the cost of applying for a rental unit and defines certain processes to ensure fair treatment for both landlords and applicants. Today, rental companies or landlords are free to charge what they want for a rental application. And the cost and processes can be excruciating for someone who's actually applying to rent a home. In times of shortage, like we're in now, fees for a simple 1 or 2 bedroom apartment is really hundreds of dollars, even in low-end circumstances. No refund policy, even if there's no rental units available. People just can't handle the multiple applications without getting any information back on whether or not there's something there. They end up having to wait. They'll wait. How long do they have to wait until they give up, and then they have to pay for another one, and how long do they wait that time? And every time they have to pay again hundreds of dollars for another application fee. Small apartments here in Lansing are now over $500 for an application fee. And you know, the cost of a credit check is less than $10. This is price gouging or prejudice, one of the two. So Senate Bill 372 directly addresses this. It defines a rental application payment as a non-refundable payment for processing the application, including the background check. It sets ground rules for rental companies and landlords, including a maximum application fee of $25. It allows use of reusable background checks, which will save money and time. It defines specific information that will be required from renters and the information that rental companies and landlords will provide to the applicants, such as the availability of rental units and with the number of bedrooms. So people know before they pay their fee that there are 6 2-bedroom units and 1 3-bedroom units available now. And then people know there's a reason for them to bother with the application. They also will provide there's information in there that's defined, which is the process and the information gathered includes the right to a copy of the consumer report used and the opportunity to dispute accuracy of any misinformation within. And in the event that an application is actually denied, it defines the specific information that will be provided to the applicant to understand why they had a denial and give them the opportunity to rebut any information that's contained in that background report. It also specifies that determining a prospective tenant's eligibility for a lease, the landlord must consider the tenant's current ability to pay rent and the sustainability or suitability for that tenant according to their rental application criteria, and to screen the applications in the order in which they're received. So don't hold this one aside while you process this one over here or these 6. Do them in the order they come in. This is all in the interest of fairness, which should reign all the time, but particularly in times of shortage and financial uncertainty for so many people now. It's time for us to ensure fairness and protect our rental home constituents. So now we will pass over to Senate Bill 373, which is Senator Cavanagh's bill. Grace, please.
Thank you, Senator Bayer. Thank you, Chair Irwin and committee members for taking up this legislation today. And Senator Cavanagh sends both her thanks and her apologies for her scheduling conflicts today. And thank you, Senator Bayer, for your work in this space and allowing this legislation to join this package for rental transparency and tenant protections. So Senator Cavanagh's bill, Senate Bill 373, is quite simple. It requires landlords to offer their tenants at least one method of paying rent that does not incur them additional fees. Far too often we see credit card fees, processing fees, convenient fees, online payment fees tacked on to rent. And many of these landlords require their tenants to utilize online payment portals, auto pay with direct withdrawal to pay rent. I myself lived in an apartment where the only option to pay rent was via an online portal that the company had established. And if there were additional fees, there would be no other option to pay those rent and not incur those fees. So additional hidden fees contribute to the growing cost of rent, and we see that the cost of rent just continues to grow. And what this legislation does to combat this issue by requiring landlords to offer that one method that is fee-free expands the choices for both renters and for landlords on the methods of collecting and paying rent, and gives tenants the ability to make a choice to reduce fees that they might incur. So thank you for taking up this legislation today, and I'll pass it back over to Senator Bayer.
Thank you. All right, and now we're on to Senate Bill 374, and this is actually Senator Geis's bill, but she couldn't make it today, so she asked me to speak to the bill briefly for her. This bill is about eviction sealing and expungement of the record. So eviction, as we know, is one of the most traumatic events that can happen to any person or family. It can really cause a family to spiral down all the way to homelessness, even when the circumstances surrounding the eviction were no fault of their own. I've seen families with two incomes lose both jobs and be evicted from their home with no place to go. Having that eviction record caused them to be denied rental housing, even after they had incomes again that gave them means to pay rent. They could not get in because of that record of an eviction. There are some bad actors, landlords, who will use the threat of an eviction, filing the eviction, but with no intent to follow through, just to get people out who maybe have complained, maybe about having lead paint, or not clean water, or mold, things that they should be complaining about that should be fixed. But so there are certainly circumstances where landlords will use the threat of an eviction to get them out of that building. Even when the eviction doesn't actually go through, that public record goes on your record. You've got an eviction in your record and it doesn't go away. And that, having that there can cause you a problem getting another place to live. It could actually cause you a problem in other ways as well, including employment. Being denied housing because of an eviction record really traumatizes the family, especially kids. They end up losing all of their structure. It's very difficult for them to get to school. Even if they get to school, they're often spotted. Kids know the difference. When you're wearing the same clothes, when you're not clean, they spot it. You are definitely in a different place. Really, those eviction records will keep families, you can actually get locked into a cycle of poverty forever. Tragic. And this simple tool to enable an individual or family to secure stable housing is to remove that eviction record from public view and then eventually expunge it completely. It's common sense legislation. With the court sealing eviction records and then expunging them after 3 years, we can help minimize those negative effects of those records, making it easier to successfully gain new housing and rebuild their lives. The bill does require the courts to determine if it's appropriate and in the interest of justice that the eviction be sealed. The bill states that the court may order the records of the summary proceedings to be sealed only if the court determines that placing those records under seal is in the interest of justice. It's really important to understand that. There are other specific cases identified in the bill. If the individual received a state, federal, or local financial assistance, or if the eviction is filed during COVID, that state of emergency, or if the parties actually agree that the record should be sealed, or if the non-payment was under $900, in which case the record can be sealed. Sealing and expunging eviction records are the quickest and easiest way to help people maintain safe, secure housing and avoid the potentially worst consequence of actually being homeless. Thank you.